guys, hope you're well. It's Kathy. Hi Sally, hi Kelly, hi Carolyn. Oh man, my phone has to ding now, of course. It's 4:30 in the morning here. Who is texting me? That is, I don't know. That's crazy. I don't. If one of the bridges collapsed in Australia, would it be on our news? Probably. I'm thinking maybe it would. All right. So a little backstory to the first thing we're gonna watch. We are not watching this trial. Way too sad. It's horrible everywhere you look. But the lawyer, before the jury even comes in, the lawyers and the judge are discussing what is and isn't allowed to be entered as evidence. And I'm going to play some of that for you. And you're going to hear exactly what the judge says to this guy. And then what he does. How he handles it. So hopefully the volume's good. We'll find out.
I sustain the state's objection to you putting in physical email images. You could in your opening say this is what I anticipate the evidence is going to be, and use the statements you had on your next slide. I think you can put that in if you have a good faith basis to think that's what's going to be testified to. It sounds like you do.
Your Honor, and I cite to 24-6-622, the state of a witness's feelings towards the parties and the witness's relationship to the parties may all. The state of a witness's feelings towards the parties, Morgan Ray's a witness, and the witness's relationship to the parties, Mr. Lewis is a party, may always be proved for the consideration of the jury. May always be proved.
We saw this judge before on a custody case. We love him.
All right. So you're talking about bias, correct? Bias?
Yes, Your Honor. Or in relationship in general, yes, Your Honor.
24-6-622.
Yes, sir.
Merritt versus State, 311 Georgia 875, is a 2021 case, says before a witness may be impeached for bias or hostility towards a party, the proper foundation must be laid by cross-examining the witness regarding his ill feelings towards that party. And evidence of bias offered under 24-6-608B or 24-6-622 is subject to a balancing test. And generally, bias is shown through cross-examination. Usually it's the other side calling, right? But it's an interesting situation here where the state's not calling that witness. You're calling a witness, or I assume the state's not calling that witness.
Respectfully, she's sitting in the state's witness room right now.
They're not calling her as a witness. So if you're calling her as a witness and you're wanting to show she's biased against your client, then the relevance of that falls extremely low because they're not relying on her testimony against your client. Does that make sense? And so going into specific acts of her bias, I mean, I've told you, I'm going to let you get in that the day of this disclosure, Ms. Ray, the mother of the child, told Mr. Lewis, you're about to see how insane I am. I'm going to let you get into that. But the nature of their relationship the reason why they're mad at each other, that kind of thing, just not relevant. And certainly not relevant I mean, if you ask the child, did your mom tell you to do something, and she says yes, then I think it becomes a lot more relevant. But until there's something like that, the state's not calling her as a witness. They're not relying on any evidence that the mom has said in their case. So unless there's some tie to show that she's influenced this child, I'm still letting you get in a little evidence, but we're not getting into a bunch of other stuff. She doesn't like Mr. Lewis.
Your Honor, all it says on here is that Morgan and Jordan divorce finalized June of 2022. It's a fact. It's what happened. It's part of this relationship. And frankly, I feel like my defense is just being hampered for no reason. I mean, I'm having to explain myself at the beginning of my opening why each piece of evidence is relevant. And I think this court, and they know that this is all good faith basis. I've provided loads of discovery. This witness is sitting in the state's witnesses room. And I'm gonna ask that you be treated as an adversarial party. Every part of this case has been adversarial. And by the definition of the statute, 611, anybody who identifies with an adverse party should be treated as hostile and adverse and should be subject to leading questions. And she identifies with an adverse party. The mom of the victim identifies with an adverse party. And so I am stressing that while she is my witness, I think that we should be given some latitude to get into her bias, because we can all pretend she's my witness, but we know that she's not my witness.
Well, if the state's not calling her, then you're calling her. She is your witness, right?
She's sitting in their office right now.
Well, we can move
So if you
her.
think she's harmful to your case, don't call her.
She's not harmful. But, all right, I understand, Your Honor. I just
And-
think
and-
that's an oversimplification to say she's the defense's witness.
And just for the record, of course, Judge will kick her out and have her somewhere else if that's what's important, okay? To inquire as to bias is proper under most situations. To say it's bias and then to, again, impeach somebody with prior instances of bad conduct is what is improper. That's not bias. That's just dumping on somebody. We're bringing witnesses about what happened in this case. I think they plan on trying a totally different case, Your Honor. Yes, they have turned over tons of records for, this mom and somebody else. They've been very diligent about complying with the discovery statute. That does not mean that that is admissible evidence in this case. This is not going to be a divorce case. This is not going to be a case where Morgan is going to be on trial in front of this jury. And that was why we were just looking to make sure that is super clear before Ms. Jackson's put in the position that she doesn't want to be in, which is objecting during somebody's opening statement.
All right, and Mr. Shapiro, the divorce date of Ms. Ray from this other person is relevant how?
It's on July of 2022, and respectfully, Your Honor, the reason why we believe it's relevant is when you go into the party's relationship, as in Mr. Lewis and the witness, Morgan Ray, the fight that they're having, I think she's going to say, I don't know what she's going to say the fight's about, but our position is that the fight has to do with, my first email in here that I just deleted was her emailing him the day of with the picture of Megan Sweet, the girl that she thought he was cheating on her with, and that's the basis. And I think that, again, we have to answer why a child would lie in this case. And our theory is that it has to do with how angry mom was at Repo. And if we can't explain why mom was angry at Repo and why they were mad at each other, which is because they were having this dispute, I'm failing to see how it's not relevant. And so I'm trying to explain why it is. It is. I mean, in a case like this where the dates aren't material and the timeline opens up to, 2 years, I think their relationship over this time becomes relevant because it goes towards how Hayden saw Repo and why she would be there for her mom if she saw this guy cheating on her mom, or her mom said, hey, he's cheating on me. Again, the divorce doesn't have to do with the legal status of bigamy. It just has to do with her divorce of Jordan has to do with her and Repo's relationship, because it has to do with where this kid's going. And again, there's nothing on here about this is when Morgan committed bigamy, this is when Morgan did this. It just says Morgan and Jordan divorce finalized. That's all it says.
All right, I'm gonna sustain the state's objection. Mr. Shapiro, don't go into her marital status with somebody else is just not relevant. So I'd ask that you not mention that in your opening statement. Do you need a few minutes to be prepared to do your opening?
I'm not prepared to do opening, Your Honor, due to the objection, so I do need about 15 minutes just to.
And let me just make it clear. I'm gonna give you some latitude to ask Ms. Ray and to argue that Ms. Ray was mad at Mr. Lewis and that your theory is that she manipulated the child. I know that's your defense, and I'm gonna give you some leeway to introduce or to ask Ms. Ray, were you mad at Mr. Lewis? Did you manipulate the child because you were mad at him? The reason she was mad at him, the other parts of their relationship, like if she was married to somebody else, who he was cheating with, who she was cheating with, not relevant. Not gonna let you get into that. If you wanna ask, for the months of July to September of 2022, where were you living? That's relevant, were the children living with you? Was the child living with you from July to September at somebody else's residence? I'll let you get into that. That's relevant.
Even December, right?
Or whenever it is. You said you want to present evidence that there are timeframes when Mr. Lewis did not have access to the child. I think you can do that for that limited purpose, because that's all that's relevant is, was the child around when some of these dates that the allegations include? I think you can do that. But we're not going to get into, well, what's your relationship with this fella that you were staying at somebody else's house, because it's not relevant. So, if mom says, yeah, from July to October, we lived at Harold's house, okay, that's it. Was the child with you? Yeah. No other questions about that, because it's just not relevant. That clears it up. The child wasn't around Mr. Lewis during that time. Not what the relationship was with Harold or whatever his name is. Just not relevant. Didn't mean to put you in that position. I was trying to come up with something that obviously wasn't involved, Mr. Buckley. This is limited to the allegations contained on the indictment.
Your Honor, respectfully, I hear you, except for I think she's going to get on the stand and say that she was with Repo the whole time, and that's not the truth, and I have evidence that that's not the truth.
You can call a witness to say, isn't it true that she and the children were living with you from July to September? That's the way you impeach that evidence.
That's the way I will plan to do it. Understanding the court's ruling, Your Honor, I just want to make my objection noted that I believe our right to a complete defense is being violated, and I do believe that this is in contradiction to 622, as well as general rules on impeaching witnesses, general rules on presenting a defense, calling witnesses, also a violation of his right to a thorough and sifting cross-examination, and generally violates the Georgia U.S. Constitution and the statutory rights of Georgia.
I don't think you get to cross-examine your own witness, but you got 10 minutes. We're going to bring the jury out at quarter till. You can tell the jury they can take a 10-minute recess.
And they still need to be sworn, Your Honor.
Yes, sir.
Yes.
All right, we're going to stand in recess for 10 minutes.
So crystal clear. All right, the trial is child molestation against this man. So the mother, what the defense is putting on is they're attacking the mother. And the prosecutor and the judge are saying that's not relevant. What she did right or wrong is not relevant to the charges against this man, against this child. It has nothing to do with the mother. It's what this man did to this child and what this child said that he did. So the judge was crystal clear there. The mother's relationship status and why she's mad at him is not relevant. You are not you are not allowed to bring that up at all. And the prosecutor is like, we really don't want to object to an opening statement. Well, we're starting the next video with the prosecutor objecting to an opening statement and objecting to something on the defense attorney's board. He has this board where he has a timeline, and he is mad. He is mad. You'll see him rip stuff off his board.
Any prior temporary protective orders that were issued against Mr. Lewis that were sought by Ms. Ray and Mr. Shapiro. I don't know if I can make it any clearer. Well, I can't see it from there, so if you want me to look at it, bring it here.
Please, anybody, please.
Now the judge is going to go through everything with a fine-tooth comb, because what he said in his opening statement was, on this date and time, she got a protection from abuse against her. Oh, I don't know what that was. She got a protection from abuse against her, and that is not relevant. He was not allowed to put that in there. He was just allowed to say they were mad. She was mad at him. That's it. It was crystal clear in his instructions. But this attorney can't get it together.
And this thing about the Hummer, is that because it's mentioned on the forensic interview?
Yes, Your Honor, that's their discovery.
Well, I'm not asking if it's a discovery. There's a lot of stuff that's not admissible. It's discovery. Is it mentioned in the forensic interview?
Yes.
And this June, July 2022 repo and Morgan split up and reconcile. Are you just doing that to say this is when the children were residing with Mr. Lewis and this is when the child was not?
Exactly, that between that July 2022 and August 17, 2022 date, that might have been a few weeks where they stayed and then moved out again.
Well, this says June and July of 2022.
Yeah, the split up is in June, July, end of July they reconcile, move back in. That's like around like July 20th, July 21st, and then they come back and stay there for a few weeks.
All right. Any other
Pay attention to when the jury comes back in, because this judge is about to slam him.
issues with this from the state?
Well, I can't. I wasn't able to read it. I guess my one concern would be whether or not, if what we're going to say about what they said about the Hummer during the forensic is the girl said, "I knew once Mom got rid of that Hummer that was really over." I don't know if this is somehow going to turn into Morgan Ray did something horrible, stole that Hummer from him, did something bad with that Hummer. You know, stole it, gave it to somebody behind his back when she committed a crime doing it. I'm going to have a problem with that, Judge.
I agree. I'm assuming that the opening and the evidence is going to be presented as this is the day that transaction occurred, because that's a triggering event or an event that's noted in the forensic interview, but not the arguments surrounding the Hummer or who owns the Hummer or who had the Hummer or who it was sold to or whether it was stolen, whether it ran or not. None of that stuff's relevant or admissible in this case.
Along with if that ruling, with that ruling in mind, Judge, we don't otherwise have a problem with it. Because, again, the child does talk about the sale of the Hummer forensic.
All right. Anything else from anybody else?
Nothing from the state.
All right, I hear toilets flushing. You want to see if we got all our jurors? All right, bring the jury in.
Here we go.
All right, everyone, please be seated. Ladies and gentlemen, just prior to the break, the state had objected. I have sustained the state's objection. You're to disregard any statements about a temporary protective order being issued against Mr. Lewis. Not relevant, not admissible, and violates a prior court order. And Mr. Shapiro, please refrain from doing that in the future. Please proceed with your opening.
He can't because he's so mad.
So during a lot of this time, what I think you're going to find out throughout this trial, such as times between July 2022 and August 17th of 2022, there's little pockets where Hayden is staying with Mr. Lewis, with Repo Lewis.
Okay, he got his composure back. It was hard. He had to pull everything together, but he got his composure back. Now, he's done with his opening statement, and they're about to call first witnesses. But this will be the first break since all this happened.
Explain to you why this was a false allegation. The evidence is going to show you that. And you're going to feel that way. You're going to feel like this is how these things happen, and this is how a kid can take the stand and say it happened even though it didn't. Because Repo Lewis did not do these things. Repo Lewis is not a child molester. Repo Lewis played a biofather and got manipulated. He may not be a perfect person. There may have been drinking incidents. There may have been yelling. But you're here to decide whether he molested a child. Now, ladies and gentlemen, Repo Lewis did not. It was made up. It started by mom. Now she's going to come in and try to fix it. And I ask y'all to not let that happen. Find Repo Lewis not guilty of all counts because he did not do it.
All right, call your first witness.
State will call Hayden Garrett.
And I hate to even ask this because y'all been outside. Did y'all get a restroom break? Everybody got a restroom break? Let me look at the parties. Either one, anybody at the end of the tables need a restroom break?
Yes, please.
Yes? Ladies and gentlemen, I'm sorry. We've been in here working. We're going to take a 5-minute restroom break. I'm going to let you return to the jury room for just a moment. And we're going to I'm going to release everybody from their table so they can go take a restroom break. We're going to try to make it 5 minutes. I'm sorry.
Oh, that's your argument.
Just take your notepads with you and hang on to them.
One of y'all said I'm raising something for the record.
Hey, Harold.
Let me go with my water. Thank you.
Your Honor, I do want to make one objection for the record, and very respectfully so, I do object to the court informing the jury that I violated a court order. There has not been one court order regarding the TPO. It has never been objected to until my opening. And I've paid very close attention to the court's orders. I've taken notes on every single court order. There has never been a court order concerning a TPO. They've always known about the TPO because I served it in discovery. I understand the court's ruling, and that's why I followed it, but I do think it was inappropriate to inform the jury that I violated a court order that never existed.
All right. So noted. I think it was pretty clear. I said nothing about the relationship other than she's mad at Mr. Lewis is relevant. And I think I made that clear. So I'm going to maintain the ruling. We're going to move forward. We're going to get this case tried. Take a 5-minute recess so you can go to the bathroom. We're going to come back at 11 o'clock and hear from the first
At this
witness.
point, I also have to move for a mistrial as to informing the jury that I violated the court order. I have to. I have no choice but to.
Any response from the state?
Response for the state, Judge, is, again, our frustration is is our inability to know what improper statement defense is going to make next. Your Honor's best advice to us, and the only advice, is just object when it happens, all right? We have repeatedly talked about all these bad things that this woman has done and how they're inadmissible. I think that at an appropriate time, it is proper for a court to admonish an attorney for failing to follow this court's instructions. No, there's never been a specific pretrial ruling on a TPO because, of course, Your Honor, we had no idea that they would actually go ahead and try to, again, bring up something bad that this woman has done. The state.
How about the motion for mistrial? You have a position on that?
Yeah, I believe that it is, there is no reason at all to mistry this case.
I'm going to decline to grant the motion for mistrial. We're going to take a 5-minute restroom break. Be back at 11 o'clock.
I wonder if he pouts like that at home if he doesn't get chicken for dinner when he wanted chicken. Oh man, that guy, the poor lawyer didn't get his way. He's trying hard, and I love it when defense lawyers advocate for their clients. I love it. I love it when they do a good job, but not when you whine and cry. Not like that. All right, let's go to nothing crazy happens here. It's just, it starts out really interesting, and then it just gets more and more interesting, and we learn a little bit more about law.
But he hasn't signed it. So that's a whole nother issue. Mr. Allen, do the people have a position on that issue? Whether someone is in custody on a case because they choose not to sign a PR bond? Or do you, I mean, they're asking for a prelim in both cases. Do you object in 24 CR 42?
Your Honor, I think we would object to that, given that it is a PR bond status in the case.
Okay. Ms. Van Soesbergen, do you want to present an argument on that issue?
I just note, that while Mr. Ritter is being held on a, unsigned PR bond here, I do think that he is in custody. I also think that the way in which we came to this, effect, right, the PR bond here was really the fault of the DA. I know I made an extensive argument about this prior, so I won't, belabor the point here, but it was
Because of the late filing of the charges, right?
correct.
Yeah.
Correct. So I did make a record, when we were up in front of that issue as to, that it's not really a remedy for Mr. Ritter, right? So, that's sort of on the outskirts of what we're really talking about here, which is whether or not Mr. Ritter's in custody, but I did want to raise that just because I've made that argument before. Certainly, I do think that Mr. Ritter is being held on that, given that it's, unsigned here, and that I do think that he qualifies for being in custody for purposes of the issue that we're talking about today.
All right. Well, I have mixed, conflicting thoughts and feelings about that issue. For today, I will grant the defense request for a preliminary hearing, but I'm not delving deep into the legal issues on that, and so I'm not bound by that in the future. But for today, I'll grant the defense request for a preliminary hearing in both cases. So would you like to schedule that?
Yes, Judge.
Okay. How about, so,
You're up.
yes?
He says he didn't sign the PR bond because he has a parole hold.
Yeah, I know that too. Thank you.
Okay.
Okay, so Ms. Van Soesbergen, you weren't in the courtroom, but Ms. Zapletal was suggesting, I'd never thought of it, but she's suggesting that we double set preliminary hearings. I'm willing to do that. That opens up a lot of other possibilities for scheduling.
Right.
The only problem with that is, generally, of course, a defendant has a right to have that preliminary hearing within 35 days. And if we're confronted that particular day with both preliminary hearings going forward, and I don't have time to do both, one of them will have to be continued. And so I'm willing to double set this against the Knox preliminary hearing, for example, on April 12.
I was gonna say, maybe if we could talk about dates a little bit and see what the availability is, and then kind of go from there.
Well, I have availability on Monday mornings, but nobody likes that. I understand why,
Mr. Court, yes,
but
Joe.
I have availability.
I sometimes have availability Monday afternoons, but
So the first Monday afternoon that I have time is the April 29. So that is within 35 days. I can do that if you like.
just double check my court schedule and Division One judge.
Sure.
I can do, so I'm available the afternoon of April 29th. But I'm uncertain what the,
Mr. Allen?
Time was that again?
I would schedule that from 2 to 4.
I think that should work for the people. Yeah. We can do that date.
Okay. Let's do it then. Both of these will be scheduled for a preliminary hearing on Monday, April 29 from 2 to 4.
and can we just be clear, just because I know that we're not gonna be having these two hearings at the same time. I think it makes sense to do 24 CR 42, maybe from 2 to 3, and then 24 CR 45 from 3 to 4, just to,
Well, I'm not so sure we won't do them at the same time. I don't know if there's evidence that applies in both cases, I will let the district attorney do both at the same time.
I don't know that that's, because it's, right, because they're two different cases and two different, I mean, they are two different sets of facts here. I would prefer to do them, to break them out separately like that. I can't think off the top of my head if there's a rule or a law about that, but certainly
I mean,
because-
they would have to hit, so to speak, all the elements of all the offenses of whatever's charged in both cases. But I don't see any reason we can't do them at the same time. You know what? I just saw something else. I guess I don't know that we have to make that decision right now, but
Okay.
I'd probably defer if the people want to do it together. I probably will grant that request. But I'm just seeing something else now. The people charged habitual offender, 2 counts of it in each case. I think Mr. Allen, you charged 1 count for the misdemeanor and 1 for the petty offense. And I know I have said in open court to people that even if, like on a domestic violence conviction, even if you're charged with a petty offense, it can be elevated to a class 5 felony if you have 3 priors. But I'm not so sure that I'm right about that based upon what I just read. Because what I just read in 186801 subsection 7 is a misdemeanor offense that includes an act of domestic violence is a class 5 felony. So I don't know that a petty offense can be charged.
You said 186801.7?
No, 186801 subsection 7.
Subsection.
That's the habitual domestic violence offender statute. So you may want to look at that because at first glance, I think you cannot probably charge the petty offense as a class 5 felony. So if you think you can, you better be prepared with some legal argument. If you agree with me, then please file a motion to dismiss those charges. Okay?
On it.
Status conference the prior week?
Yes, Judge.
That'll be April 23 at 2 p.m. for a status conference.
I'll talk with Mr. Ritter about this as well. I'll be out of town, but I'll find coverage for that.
Okay. Anything?
So first off, the guy got an OR and he never signed it. He refused to sign it. He's sitting in jail. And I get that. Like if he thinks he has a hold somewhere else and that's why he didn't sign it. And I would do the same thing because if I'm going to sit in jail for something, I'm going to get credit on all of my cases, all of them, every single one of them. So, that's the first time I saw someone get an OR and not sign it like that. But then the habitual offender, if you are a habitual offender, they can increase everything except for petty crimes. So like petty crimes can't be felonies now, which is crazy that a petty crime can be a felony anyway. But I thought that was just interesting. It made my brain hurt a little bit as I was looking through it. Now this next court, the lawyers get in trouble. Just the lawyers just are not doing a good job. But there's a heartwarming moment. Don't worry.
There was a warrant issued on January 12th. Well, actually, it was issued on the 11th. Is there an active bench? Yeah, there is. So, where's Mr. Keegan go?
The allegation was a violation of the pretrial diversion program, and he's been in contact with me. I reached out to the therapist and the provider, get a better understanding of what was happening, and then it was a little bit of back and forth with the state's position during the transition, EPA's. But once we got the communication we needed, I asked us to be set for hearing to bring him in on this warrant. And that's what we're here for today, is to ask the court to address the outstanding warrant. The issue here is the violation, the alleged violation of the felony pretrial diversion program. He has no history for this case.
Obviously, that's good. They've done pretrial diversion.
Right, and I can debate the merits of the allegations contained inside the violation, but I think at the end of the day, we're asking the court to consider allowing him to be released without being taken into custody. He wasn't treated before this case started. He went through treatment during this case. Ian Curtis is still interested in continuing him with his treatment, and in my discussions with him, I think that would be a better path forward while this case.
Well, that would have been a great path, but I guess I'm concerned about your client's ability to show up for court. And then I'm somewhat concerned, with all due respect to you, Mr. Britton, is you're in communication with this person and you're waiting, there's an active warrant, it's a court order. And it's like, well, we'll wait and see what we can work out with the state before we bring them in.
We don't know, that's mine. I can take the responsibility for that.
I'm pointing my finger at you.
Well, I mean, we filed a motion. I typically have to provide the state's position on what they want to do. And, I reached out to Ian Curtis and got information from him, which took a little bit of time. And I reached out to the state, and it was signed by not typical CAD deputy court. And I had to get her position of what they were interested in doing. So,
And so here's, but this, Mr. Britton, this. The warrant was issued in January. I don't know when you had contact with Mr. Keegan, but all you had to do without even talking to the state is to bring him in. That's all you had to do. Bring him in and say, hey, you know what, whatever. We'd like to get some time to sort it out. Now we're not talking about a warrant at all. We're talking about, okay, come back. So how am I going to make sure that Mr. Keegan appreciates it? I mean, where's he been for 3 months? He knew he was on pretrial diversion.
he was
2 months, I guess.
here locally living with his mother still in his home. So I don't think the issue is on his failure to appear in court. He's always been compliant with that. My issue ultimately was he has most certainly some mental health issues that are being addressed, and we're trying to understand
Well, I'm sorry to interrupt you. Mr. Keegan, let me make this abundantly clear to you and your mother or whoever's here with you, that if you fail to show up for court next time, you are going into custody. And you'll have to post a bond, not gonna be $500 or $250. It's gonna be a considerable bond. Do you understand me, sir?
Yes, Your Honor.
When are we coming back, Mr. Britton?
Your Honor would ask for that same status date in April.
Well, he's not in custody.
We can push it further. I just need a chance to work with the state a little bit.
Well, you're gonna be here on the 25th, the 25th of April.
We do that too.
So, Mr. Keegan, your next court date is February 25th at 9 o'clock. April 25th, thank you. Nothing like confusing, you, right? April, what did I say? February. Well, you guys are paying attention. Were you? Oh, April 25th. Sir.
Okay.
When you coming back?
April 25th at 9 a.m.
Right. Morning's vacated.
Okay.
Thanks for getting dressed up, sir. Very few people do that. I appreciate that. Thank you. You're welcome.
So the judge just had to yell at this lawyer because that guy had a warrant out for his arrest, and the lawyer didn't bring him in. The lawyer said, "No, you don't have to come in. We're going to wait to see what the state has to offer." Well, this lawyer messes up even more in a bigger way.
What are we doing? Hello, Your Honor. How are you? Good, sir. What are we doing?
Have J. Clayton Gardner here, and sorry to spring it on everyone, but I have a plea agreement that
We need copies, mate.
I have 3 originals, Your Honor, if that's sufficient. I sent this to Mr. Gardner electronically. He reviewed it by email, and then he signed the hard copies that I brought with me.
Your name like this should be an awesome.
He's a musician. So,
Hey, Mr. Gardner, stand, raise your hand, please, will you? Swear to tell the truth, the whole truth, and nothing but the truth, so help you?
Yes, Your Honor.
All right, sir, have a seat, please. So what's your, I need to ask you some questions. Your lawyer's filed a plea agreement. What's your full legal name?
J. Clayton Gardner, Jr.
How old are you, sir?
22,
How far did you go in school?
11th grade.
You read and understand English?
Yes, sir.
Your lawyer has filed a plea agreement. I go to the last page, I see 3 signatures. Do I recognize that of Mr. Gady and that of your lawyer, Mr. Masters, that 3rd signature? Is that your signature, sir?
Yes, Your Honor.
Did you read this agreement before you signed it?
Yes, Your Honor.
I'm going to ask you a series of questions, make sure that what's happening, what you're doing, that you're entering into this agreement freely and voluntarily during the series. If you have any questions, please ask me to stop, and I'll give you time to consult with your lawyer. If you're not a citizen of the United States, conviction of the charge or charges filed against you could result in less favorable immigration status or deportation. If there to be time to seek legal advice about this issue if you wish. Is that an issue, Mr. Masters?
No, Your Honor.
Are you currently under the care of a doctor, psychiatrist for a condition or under the influence of prescription medication and any other medication, drug, or alcohol that would affect your ability to understand what you're doing today?
No, Your Honor.
Okay. First part of the plea states that you will plead guilty to resisting law enforcement of Class D misdemeanor. And the parties will be free to argue. Is that your agreement with the state, sir?
Yes, Your Honor.
Had you gone to trial? Do we have a charge that was filed?
It's.
I just see one time unless you filed something.
No, shoot.
Mr. Gady is then make an offer. I used to be added account that you're on to plead guilty to before we did the plea. Let's see. 532.
Excuse me, John. Would you like my pocketbook? I have my thumb on it.
What page?
On the 2023 edition, it's on page 225. Subsection A1 for forcibly resisting.
Okay. So you're gonna file something, right, state?
Just send an email and a task to Mr. Gady.
Yeah, tell Mr. Gady that from now on, when he's gonna do a plea, when they plead to account that does not exist, that I would appreciate that the account be filed before the plea.
Well, as Mr. Masters just stated, his client just agreed to the plea this morning.
Well, but he could add the count, sir, with all due respect. You could have added the count in anticipation, but you know what? We won't do the plea, and you guys can do your job. Come back.
We can do that, Your Honor. I'll say John actually saw him at the gym on Thursday night, and that's where the genesis of this came from. So we did move with some alacrity, Your Honor. But
I don't know what that means. What does that mean?
alacrity,
Yeah,
speed, purpose.
Thursday, Friday, you had the weekend, and then today. That's a long time. To do a simple charge. If you had an agreement, then something should have been filed. When would you like to come back?
Whatever you like. I'm with you on Thursday. If that's not asking too much. I could be there on.
I don't know, I was willing to do the plea today, except I don't have everything I need to do it. So 28th is fine.
Okay to come back Thursday. They got a file submission paperwork.
Does that give Mr. Gady enough time to draft the count two, Mr. Dab?
I hope so.
All right. See you on Thursday, sir.
Yes, we are. I'm afraid to.
And you too.
I'm sorry, before everybody walks away, I just got through email here. Added count 2 for Mr. Gady.
Okay, he emailed you.
Well, through the e-service. So through the Odyssey e-service, it's just showing there.
To get it with the purpose, that's what
Then I'm getting it.
I think if it's served,
Validated.
I don't have. We want to take a minute and
I can
ask
remind
Mr. McCurdy and see if it's there.
Give me the back, or give me the papers back. All right, sir, had you gone to trial on the count you're pleading guilty to, the state would have to prove back on or about June 14th, 2022 in St. Joseph County, state of Indiana, you did knowingly or intentionally and forcibly resist an use syllabus. A law enforcement officer, while said officer was lawfully engaged in his duties as a law enforcement officer. There you go. Something the state would have to prove, but in as much as you're admitting guilt to the charge, the state won't have to admit. The state won't have to prove the charges when there's no trial, but instead of judgment and conviction be entered in sentencing code, if there's no trial, given the following trial rights. Speedy public trial for judge and jury. To confront and cross-examine state witnesses, to call witnesses on your own behalf, if you know to testify. You understand you're given up those rights, sir?
yes, Your Honor.
Any questions about those rights?
No, Your Honor.
You're also given up the right to appeal your conviction. I don't know that you're necessarily giving up the right to appeal your sentence, but you definitely are giving up the right to appeal your conviction. You understand that?
Yes, Your Honor.
Sentencing range for a class A misdemeanor, 0 days in jail, to 365 days in jail, and a fine of up to $5,000. Were you out on probation, parole, bond, withheld sentence on any other offense in this offense?
No, sir. No, Your Honor.
Eligible for community corrections, I take it, Mr. Masters?
Yes, you do, Your Honor.
Sir, after, having gone through the rights, you're waiving possible punishment probation, you still want to plead? Are you still willing to plead, sir, or no?
Yes, Your Honor.
Okay, I don't want to force you to plead if you don't want to. Do you want to plead?
Yes, Your Honor.
All right. Nobody's forcing or threatening you to plead?
No, Your Honor.
Have you made any promises to the state or has the state made, sorry, have you made any promises to the state or the state made any promises to you, not in the plea agreement?
No, Your Honor.
Okay. Or it's not bound by this agreement, if I accept it, I'll be bound by assurance, which means I can't in future produce or suspend and impose that unauthorized by agreement without the state's permission. If I reject it, the plea will be treated as if it never existed. Understand that?
Yes, Your Honor.
Other than the terms of your plea agreement, you guaranteed what your sentence would be. I have it with your lawyer, Mr. Masters. Are you happy with Mr. Masters? Okay, do you still want to plead guilty?
Yes, Your Honor.
The Masters for actual pleas, sir?
Thank you. Hey, Jay, I want to ask you to think back, it's a couple of years ago now, June 14th of 2022. Were you in Mishawaka in St. Joseph County, Indiana that day?
Yes.
Were you at home?
Yes.
Did something prompt the police to come to your home?
Yes, although I was unaware of what it was at this time.
Okay, so you didn't know why they were there, but they came nonetheless, right?
Yes, sir.
Did you get into a conversation with a police officer, in short, trying to figure out why they were there?
Yes.
And you knew this gentleman was a police officer based on his uniform and how he was acting, right?
Yes, sir.
Now, it's alleged the charging information, his name is Andrew Silvius. I take it you probably didn't know his full name then, but do you dispute that that's the man's name?
No, I do not dispute.
Okay. So you were having this discussion with him and it got a little heated because you still didn't understand why they were there, right?
Yes, sir.
But at some point, this officer placed a handcuff on one of your hands, right?
Yes, sir.
And at that point, you knew enough to know that even if you weren't being arrested necessarily, you were being detained, right?
Yes, sir.
At that point, you should have just stopped and given him your other one, right?
Yes, sir.
But instead of doing that, you pulled your arm away from him, right?
Yes, sir.
And he eventually had to sort of twist your arm and put the cuff on you that way. Is that right?
Yes, sir.
And we've talked about this idea of forcibly resisting, and it's not as if you were in a wrestling match or fist fight, but you understand by pulling your arm away, you were forcibly resisting, right?
Yes, sir.
And actually, 2 days after you got released, well, when you got out of jail, when you posted bond, did you go to the police station and apologize to them?
Yes, sir, I did.
If you could go back in time, would you do this again?
No, I would not.
I'll pass the witness there, Your Honor.
Dave?
I have no questions.
I'll learn my lesson.
All right, sir, when you plead guilty, give up any defenses, I have to understand that.
Yes, Your Honor.
You're making it a crime of resisting law enforcement, class A misdemeanor, is that what you want to do?
Yes, Your Honor.
Okay. Okay, the court finds the defendant understands the drugs charges, possible penalties, and into the plea freely and voluntarily, provided a factual basis. Court now conditions accept the defendant's plea, so what do you want to tell me about your client?
I counted altogether, I believe, 8 days that he spent in jail. 2 nights when he was arrested, and then there had been a failure to appear during this case where he spent, by my count, 6 nights. But the failure to appear, it was a result of him having spent a very lengthy period of time in an inpatient substance treatment facility, and not getting back to court in time, which is why we're looking at a case for the year 2022. He's 22 years old. He continues to keep up with both mental health and substance abuse treatment and therapy. I think that in addition to accepting a plea agreement, which is a mitigating factor in his favor, asked the court to consider his behavior before he ever met me or before he was ever offered a plea agreement, which was he truly did go down to the Mishawaka police station and apologize to the officers and told them he didn't conduct himself very well on that moment. I think as somebody 22 years old, I'm almost twice his age. I think that this is a learning experience and probably a growing experience for him. He's a soft-spoken young man, an artistically inclined young man. Suppose I'd ask the court to consider time he already spent in jail enough of a sanction, Your Honor. If the court, however, wishes to keep him on probation for a period of time, he's already doing substance and mental health treatment, so I would expect he would do well on probation. He's certainly got the right attitude about self-improvement. Thank you.
All right, so thank you, State.
What's his prior misdemeanor? Oh.
Leaving the scene of an accident.
How long was he in custody?
Had 2 days at the initial arrest and then 6 days when he came back from rehab and had failure to appear warrant executed. So I have 8 nights is what I counted. Well, for Mr. Downs, excuse me.
Your Honor, I have no objections to Mr. Masters' proposed resolution.
Nick, you want to join Mr. Berger?
I definitely learned my lesson here, Your Honor. I acted out that day in a very belligerent manner. And at the time I was dealing with substance abuse, although that's not an excuse for my behavior. I did go and get treatment for that, and that's not a problem I deal with anymore. I've learned a lot in the past years. I've grown up a lot, and I don't want to be a problem for police officers at all. I respect police officers, and I feel very regretful for the action I made that day. Although I did learn a lot from this, and have I have improved myself a lot through this whole ordeal. Came out very lot stronger in the end, and I take accountability for all my actions.
All right, sir. Thank you. All right, I'm gonna sentence you to 16 days in the county jail for the surrogate you with the time, court costs, it's a PD fee.
It is, Your Honor.
PD fee of $100, the remainder of the bond will go back to you by check. You just need to put your address down there so people can read it.
Yeah, you posted 2 bonds, actually. What's your address, Jim?
It's 1505 Louis Block.
Mishawaka?
Yes,
What is the zip code on that?
46545.
Thank you, Mr. Campbell.
All right, so you're all done with the case. You get a check from the clerk. Relatively quickly.
You got sentenced to time served, you know,
I did?
Yeah.
Oh my
That's
God.
even better than you thought, right? I know, yeah.
You said I had to do time.
No, you
so
did
much,
8
Your Honor.
days, you get day for day credit, 16 days would cover the 8 days you were in.
Have a good life.
Thank you so much. You're welcome. I appreciate it.
So there you go. Create a plea agreement when there's no charges filed at all. No charges were filed yet. And he came up with a plea agreement. And the DA, no, sorry, the prosecutor just sat there the whole time. It was his fault. It was his office's fault that there were no charges filed yet. But then he came through and he found that the charges were magically filed right then and there. Hi, Jim. But yeah, the ending was heartwarming. He doesn't have to spend any more time in jail. Aw, so nice. So nice. Well, guys, that's what I have for today. But let's talk about Australia a little bit, can we? Okay. This trial is crazy long and crazy. Just this lawyer is unbelievable. It doesn't matter what question it is. It doesn't matter if the question is really important or not important at all. You're going to answer this lawyer the way she wants you to, or she will keep going until she gets the answer. Not only that, she's talking to these doctors who are doctors. She's a lawyer. And yes, lawyers are smart, but that doesn't mean they know body parts and, they know doctor knowledge. They know law knowledge. No, not this lawyer. If that doctor says something on stand that biologically isn't correct, she is on him It is amazing. However, it is a touchy situation. So, from what I can gather from this Australian feed on YouTube, is they start the live, and as soon as the live is over, they take the live down. She just take it down. So far, I have been able to get every single minute. I got every single minute so far, don't worry. And then it starts again tomorrow at 10 a.m. Australian time. So now I have to do math. And hopefully I get it all. Now, there's no possible way y'all are going to watch this whole trial, because then it goes into next week. Next week, she's calling her expert witnesses. But I can't promise you I'm going to be able to get every single minute, but God, I'm going to try very hard. I'm going to set alarms. Don't worry, Carolyn. I'm going to have that feed up. I'm going to set alarms, or I could just start recording now. Use up all the space on that computer. Who needs space? Oh my God. Now even my computer will say, Kathy, I think I need more space. To me. I try not to love my computer too much, because then it'll just go away. It'll just leave. All right. So I'm going to go in and I'm going to try to edit out the breaks, lunches, and everything like that. So far I think I have like 17, 18 hours sorry, in this trial. Tomorrow's going to be another 8-hour day for this trial, and then next week, I don't know if it's a 3-day week or not, and I don't know if it goes past next week. But I do know that while I'm getting these Australian computers, I am limiting my ability to get other courts. Yeah, Kelly, I don't know what is going on. I am never, ever, ever sick. If I ever call into work, I would have to be dead to call into work. 2 months ago, I got pneumonia. Out of nowhere. I never get sick. The day after I gave birth to my middle child, I stood as maid of honor in a wedding to my best friend. I mean, never do I get sick. So I got pneumonia 2 months ago, and I have never been good since then. And now I called in sick tomorrow. I called in. Let's watch one more. Okay. Cha. I can do something a little sketchy. Hold on. I have an idea if you want to watch one more. It's really sketchy. I shouldn't do this. I really should not do this. But I got a 5-hour clip from earlier today that I didn't see yet. I don't know what's on it. I don't know if it's good. I don't know if it's bad. I don't know who the judge is. I don't know what state we're in. We could just play that for a little bit. Oh, Cha, you're sick? It's horrible, isn't it? All right. Here we go. Oh, please don't be bad. Maybe we'll get a nice Karen.
Good
All
morning.
right, Colorado.
Morning. I just wanted to disclose, Mr. Paulson, there's several people from the Denver DA's office that work for the Adams County District Attorney's Office. I worked with Mr. Paulson. I was actually a supervisor for a bit. I don't socialize with him. I don't have the opportunity to do so. I'm comfortable moving forward, especially in light of the nature of today's proceedings, but are there any concerns that you have?
No.
Okay, I just wanted to be sure. All right, with that underway, for those who are listening, if you want to write down your court date or your bond amount, please feel free to do so. There's pen and paper at the podium. With respect to protection orders, it means no contact directly or indirectly through any means. Additionally, if it's an alleged act of domestic violence, the Brady Act applies, and I will advise you about firearm relinquishment. You need to relinquish any firearm or weapon within 24 hours.
Usually at the very beginning of a jail docket like this, the judge goes through a whole long list of stuff. So I'm just going to pop it forward a little bit. This camera angle is weird. All right, we'll start with her.
And grant her a PR bond in the amount of $507. The next court date is in Division R. And that is on, I could either have Ms. McGann either April 2nd, it looks like, or April 16th. Do you anticipate she's still going to remain in custody?
April 16th, she has an FOP court date this week.
Okay, April 16th then will be the date. And you will need to apply and qualify if you want the public defender to continue to assist you. All right, if there's nothing else, we'll conclude that matter.
That's at 1:30, Your Honor, correct?
Sorry, yes, 1:30 arraignment, April 16th in Division R. That is an in-person appearance. Okay, ma'am?
Could we next call Ms. Diaz-Meza?
Your Honor, is the interpreter still online?
She is in a breakout with Ms. Citizen, no?
Well, they lost her. So
Oh,
if she's
okay, let me
still
look.
there.
I'd have to look at the breakouts. I don't have that screen up. It looks like we did lose them. As soon as I see her back on, I'll put her back into the breakout.
Thank you.
I don't know what happened.
Yeah, thank you.
Okay.
Ready next on Ms. Diaz-Meza?
This is Eleanor Diaz-Meza. It is 24 CR 962. Again, 24 CR 962. Bond argument on behalf of the defendant.
Your Honor, we're asking for a reduction to a PR bond or a $2,500 cash or surety bond. I looked at the record for 22 CR 263. Ms. Diaz-Meza was originally sent to the diversion program. It alleges that back in September, she was discharged from that program. I did not see a motion indicating any kind of violations. I just had that information from the minute order. But the bond is currently set in that case at $5,000. In the affidavit in this case, it appears that neither party wanted to cooperate at first. Neither gave a statement to the police. Eventually, both parties claimed self-defense. Both parties had visible injuries. It's unclear how police determined who is acting as the aggressor and who is acting in self-defense based on the information in the affidavit.
We should see both of them.
Diaz-Meza has strong ties to the community, having lived in Colorado her entire life. She has lots of family here, and including aunts and cousins that can serve as a support system. But I think most importantly, Your Honor, Ms. Diaz-Meza has really strong stability for herself. She has a stable place to stay where she lives alone and has been for the last 4 years, and has a stable job at Stanley Marketplace as a line cook where she's been for the last 3 years. Her primary concern is losing the stability that she has built for herself, especially when it seems that the allegations in this case are up in the air based on the information in the affidavit, which is quite limited. She's only a CPAT score of 2, has no history of revoked bond or supervision, and has no failure or one failure to appear listed on the CPAT, but that was from back in 2009. So nothing within the last 5 years, but for the diversion case. So for these reasons, we're asking for a PR bond or a $2,500 cash or surety bond. Thank you.
Thank you. And before I proceed further and hear from the people, I should go ahead and move forward with advising her about the protection order. So this is an alleged act of domestic violence, so the Brady Act does apply. I'm going to check provisions 1 through 6 and 8B. You're to have no contact whatsoever with Justin Abbott. 115 of 77, directly or indirectly through any means. You also have that obligation to relinquish any firearm or weapon within 24 hours you're released from custody. And within 7 days, you're released from custody to file an affidavit with the court that you've complied with that provision. Do you understand that obligation? Thank you. And is there a request for a civil, you said no request for a civil assist, Ms. McGann?
Parties don't live together.
Okay. Mr. Paulson, on behalf of the people.
The people had asked the bond remain at schedule. There's two primary concerns. One, the seriousness of the allegations, the use of a knife against another human being. Second, the defendant's domestic violence history. The diversion case was mentioned. That diversion case has a warrant because she was non-compliant on diversion. The diversion case is its own felony domestic violence assault case. She also has a 2009 domestic violence assault, or a 2009 assault case rather. Excuse me, it looks like it's from 2007. So she has a history of violent behavior, and the circumstances of this are very concerning in terms of the use of the deadly weapon.
Thank you. The matter comes on for an individualized bond. The court has had a chance to consider the arguments of counsel pretrial services report and the arrest affidavit. In this particular case, the court did read the arrest affidavit a few times as far as how, if at all, the self-defense is relevant. The court notes that, but ultimately those issues are for a fact finder. In terms of for purposes of bond, the way the court read the arrest affidavit was that both were not forthcoming with law enforcement initially, both parties. And then ultimately that she had indicated that there was an altercation. It looked like, according to her, a day had passed. She didn't call 911, and then this incident with the knife occurred. So the court does look at these, though, as far as favorable to the people. The court has found probable cause for the arrest, but the court did consider those circumstances as far as what appropriate bond is set. The court will note that there is this failure to appear on another case that is a significant case in the history. The court, though, also recognizes her CPAT score of 2, score of 28, and some of the stability factors in the community that she has. Balancing all those factors, the court is going to go ahead and set bond in the amount of $7,000, cash or surety, that this should be sufficient as far as in a reasonable bond in light of all those circumstances. The court will appoint the public defender's office to represent her if she remains in custody. The next court date will be Division 7 on March 28th for a return of filing of charges at 1:30. The court will also note, as to the other case, 22 CR 236, it's a failure to appear. Bond is set in the amount of $5,000, cash or surety with SRP. The next court date is Division 7 on March 28th for a setting of preliminary hearing at 1:30. So that same court date, March 28th, 1:30, Division 7.
We should see the other person who was in the fight, since they didn't know who they both claim self-defense. Often I see both of the people in the jail, so hopefully we see the other one.
Print your name here by the top X. Signed by the internet.
So the parties are aware, we do have people that are for the Gallegos matter. So whenever we want to call that up.
Your Honor, Mr. Gallegos is over there at the courthouse for another case.
Okay, so are they going to be bringing him in person?
He's there for, and I can tell you what courtroom he's in.
He's got to be brought here for advisement.
Do you own any firearms?
And Mark Fox will coordinate on that.
Print your name here and sign there. I can tell you what courtroom he's in, Your Honor.
Well, we'll have to have him here. I've done this dance before, and they will not advise him in the other courtroom, so I could just have the clerk coordinate. And what courtroom is he also in?
A second. Just look that up. He is in 307 with Judge Garland.
Oh, Magistrate Garland on a protection order issue?
Yeah, I guess, yeah, it's courtroom 307.
Okay. We'll coordinate with the sheriffs to have him then come in person.
Okay, this is the supervised release program that she scheduled, that she assigned you. You need to call this number within 24 hours after you get out of jail. If you don't call this number within 24 hours after you get out of jail, they will put out a warrant for your arrest. Okay, and this is your copy. of it.
Do we need to resume any breakouts for this? Looks like we do. I just saw an answer.
Yeah,
to
if
that.
the interpreter's back on, if you would do that, please.
Okay, I see that now. Okay, my only concern, Ms. McGann, is how you would communicate with Mr. Gallegos about a bond argument. It sounds like he is at the courthouse in a protection order division.
We can do a breakout room. I can give the court my cell phone number if we need to, but I'm not sure.
Okay. All right, we'll cross that bridge when we get there. As far as a breakout, though, he'd be physically here in court. So I'm not sure how we'd be able to do that.
What I've done before is the court will leave a deputy in the room and have the judge leave, and then they use
Okay.
the courtroom WebEx.
That makes sense. Okay. All right, Ms. McGann, who are you ready on?
Jason Halstead?
Is it Haltom?
Halstead?
Halsted. Sorry, it's very faint. It's hard to hear. Okay. So if you could speak up as best you can, that will be helpful. So Jason Halsted, this is 24 CR 930. Bond argument on behalf of the defendant.
Your Honor, we're asking for reduction to a $2,500 cash or surety bond. Mr. Halstead has a lot of stability factors. He stays at his home with his mom, where he's been since 2016. He works at his mom's liquor store and picks up odd jobs. He does have some mental health diagnoses, but is interested in getting connected with services on the outside. He also has strong support through his wife and his sister, and they can provide him transportation back to court. He has a working cell phone and an email address. He shared both of those with me. It indicates on the CPAT that he's currently under supervision in Jefferson County. He represented to me that he finished out that supervision and doesn't have any right now. Your Honor, I've had a chance to review the affidavit in this case. It sounds like it was a third-party witness only, but neither parties involved in the incident reported things at first. We are recognizing the CPAT score. We're not asking for a PR bond, but we are asking for a reduction to $2,500 cash or surety.
Thank you. On behalf of the people.
Thank you, Your Honor. The people believe that schedule is appropriate in light of the defendant's CPAT score of 4, and the fact that the defendant appears to excuse me, I thought he had a prior palpo. It does not look like he has a prior palpo. Nevertheless, he's contacted with a weapon, and the people believe that schedule is appropriate with his criminal history.
The matter comes on for an individualized bond argument. The court has considered the arguments of counsel, the pretrial services report, and the arrest affidavit. The pretrial services report places him in a high-risk category, score of 4, a specific score of 55. He has a lengthy criminal history. It's clear that he was prohibited from having a weapon, and the criminal history shows crimes against persons. That does not show, while the defense has been able to supplement some information, that there hasn't been a lot of stability. He has resided in the area for some time. The court also notes that he was not forthcoming with law enforcement when they were trying to locate the weapon. And this was a weapon that they had found on his person after multiple searches of his person. The court will go ahead and set bond it in the amount of $5,000 cash or surety, that the customary amount is appropriate. The public defender's office is appointed. What if he remains in custody? The next court date will be Division 7 on March 28th for return of filing of charges at 1:30. Are we in a position to call either one of the PR bond matters so that they could get processed sooner? Is that something?
Mr. Robinson?
Let's go ahead then and call Robinson, Rylan Robinson. Good morning, sir.
Your Honor.
This case number is 24M1313, again, 24M1313. In this particular case, I believe that the people do not have any objection or agreeing to a PR bond. Is that correct, Mr. Paulson?
Yes, thank you.
All right, sir. So what that means is the court's going to go ahead and issue a PR bond in the amount of $500. This means you're going to be released with your own promise to return to court. Okay, sir, without posting any monetary amount. The dates that I have available is either April 2nd or April 16th. It would be an in-person appearance.
We can take April 2nd.
Okay. So, sir, your next court is April 2nd in Division R in person for arraignment at 1:30. And if you want the service of the public defender, you need to apply and qualify, okay? Okay, sir?
Your Honor, the other PR bond needs a Spanish interpreter.
Okay, we can just wait on that. And who would you like to call next then?
We call Quentin Lester.
Yes, this is 24M1309. Again, 23M1309. I have a notation here that this is an alleged act of domestic violence. Does that comport with the people's understanding?
Yes, thank you.
Okay, so the court will go ahead and issue a mandatory protection order. It is an alleged act of domestic violence, so the Brady Act applies. I'm going to check provisions 1 through 6 and 8B. You're to have no contact whatsoever with Denny, DENNEHY, 128 of 76, directly or indirectly through any means. Additionally, you have an obligation to relinquish any firearm or weapon within 24 hours you're released from custody. Within 7 days you're released from custody to file an affidavit with the court that you've complied with that provision. Do you understand that obligation?
Yes.
All right, thank you, sir. With that in place, bond argument on behalf of the defendant.
Your Honor, we're asking for a reduction to a personal recognizance bond or in the alternative, a $100 cash option. Mr. Lester has strong ties to the community, having lived in Colorado for 6 years. He has a friend he stays with named Eugene Coleman, and away from the named victim in the case. He is on supervision in Broomfield and doing well there. He has an appointment tomorrow that he's hoping to get out and participate in. He is on medication for hypertension and seizures. He's currently not receiving that medication in the jail. He has a cell phone number and an email address that he has shared with me so his attorney can get in touch with him in the future. Your Honor, I don't see any failures to appear listed in Colorado in recent cases. It looks like the history out of Ohio is significantly older. But most of it is significantly older, including most being over a decade old at this point. So despite the high CPAT score, I think there are some mitigating factors and strong ties to the community. We're asking for a PR bond or a $100 cash option.
Thank you. On behalf of the people.
Your Honor, the people that asked for bond be at schedule. The defendant is a CPAT 4, and most concerning is the community safety aspect specific to this victim. She was obviously attempting to get help in a VPO circumstance, and the defendant was preventing her from doing that. The defendant's doing that while he has pending cases, 3 of them going on. They appear to be domestic violence in nature. I'd also note that the old Ohio case also includes domestic violence tags as well, understanding they're old. Given his current pending cases and what occurred here, we'd ask for scheduled bond.
Thank you. The matter comes on for an individualized bond argument. Defendant is a CPAT category 4, a score of 51. The court has considered arguments of counsel, but also reviewed the arrest affidavit and some of the aggravation there. He's also on supervision, which that would assure the court as far as being supervised in the community, but it is concerning to the court. So in light of all the circumstances, the court does believe that the customary amount is appropriate here and will be set at $1,500 cash or surety and comply with probation. The public defender's office is appointed if he remains in custody. The next court date is Division 4 on March 28th for arraignment at 1:30.
Your Honor, could we authorize a civil assist just in case?
Yes, the court will go ahead and authorize a civil assist. What that means is, check 8A is with the assistance of law enforcement only. You may retrieve any undisputed property of yours.
Some new people joined, so just so you know, the stream ended a little bit ago, and we just wanted to keep it going. So we're playing a clip I have not seen at all yet. So I don't know what's happening. I don't know if it's good or bad. This is new to all of us.
I'll trade you. Print your names on the top line.
Okay, I just want to let the parties know that they do have Mr. Gallegos. I don't know what's the most efficient, balancing all the priorities. I could step out now if that's helpful, or how would the bailiff like to proceed?
Your Honor, if we could finish the folks we have before the citizen is done and then run the interpreter. When we kind of get to the end, we can trade off, but I'm writing out a couple more, but you want to get here.
Ms. McGann, I can't hear you at all. I can kind of glean some of what you're saying, but I think what I heard you say is you'd like to continue for a bit longer and get the interpreter matters.
Yes, I'd like to just power through until Miss Citizen is done with the interpreter cases, and then can step away and meet with folks we haven't met with yet.
Okay, thank you.
So we're ready on Ernie Ortega.
The sheriff's gonna come back. Has he already handled his matter with Magistrate Garland? Okay. I'm sorry, Miss McGann, I was coordinating with the deputy.
Ernie Ortega.
This is Ernie Ortega, 22M2060. Bond argument on behalf of the defendant.
Your Honor, we're asking for a reduction to a PR bond in this case. This is a pretty significantly old case. Obviously, it's a 2022 case. Mr. Ortega was already sent back to DOC for his 3-year remainder and was just paroled out. Despite the fact that this case was filed, he was never brought back to Adams County to resolve it. So I don't think it was his fault that this case remained open when he's been serving a DOC sentence resulting out of this exact conduct. He was also sentenced to 2 years of probation in Douglas County in December to run concurrent with his parole sentence. I verified that he was sentenced to probation in that Douglas County case. He has a safe place to stay at his brother's house in North Glen, where he can get rides to and from court. He represented to me that this is his first time on parole, and so he's eager to be able to start complying immediately and not be detained here and then get in trouble with parole and risk any additional remainders. He has a job lined up doing concrete where he worked before his sentence, and he's been for the last 23 years. And he has a working cell phone. You have a working cell phone, correct? Okay. He has a working cell phone, and he's obviously under supervision in 2 different ways. I think this case will be easily resolved, given that it's a misdemeanor unauthorized absence and he has a significant amount of credit. So I think a PR bond is appropriate at this time. Thank you.
Thank you. On behalf of the people.
All the charges and the CPAT certainly suggest some sort of bond is appropriate. I defer to Your Honor on whether to give a PR bond or some sort of reduced bond in light of the fact that the defendant wasn't brought over in the last couple of years and he's on parole at this point.
So the court matter comes before the court on an individualized bond argument. Defendant is a higher risk category, a score of 4, specific score of 6.
Is she going to give him a PR or is she going to give him a bond? I'm going with PR.
The indication is that he's on probation in Douglas County and is now paroled. It sounds like he will have steady employment. So balancing all those factors, the court believes that the appropriate amount of bond is $1,000 cash or surety, or a $100 cash only option in light of these circumstances and to comply.
I was wrong.
with parole and probation. You don't have enough information for it to be a PR bond. The court will go ahead and select, I could either select April 2nd or April 16th. Would you like the soonest date?
April 2nd, please.
April 2nd in Division R for arraignment at 1:30. Public Defender's Office is appointed to represent the defendant if he remains in custody. Who would you like to call next?
Mr. Renner, one moment. Your Honor, I think that's everyone that I advised. If you want to call some out of counties, I can meet with the other folks here.
Okay, sure. Let's go ahead and call Ryan Haltom. Is Ryan Haltom in the courtroom?
Still a refusal, Your Honor.
Okay, he's a refusal. So I'll pass that. How about Jesus Ramirez?
Ramirez? Oh, Your Honor, he's. Yeah, Jesus Ramirez. This Jesus.
Mr. Ramirez?
Yes, ma'am.
Good morning. So, sir, actually, this looks like one that you're entitled to a hearing, so we're going to have to pass this. I apologize. The public defender is going to want to argue bond on your Adams County case. So let's go ahead and call then, if we could call Chad Carter.
He also met with the public defender, Your Honor.
Did he? I don't show that this was a first appearance. Do the people show that he's entitled to argue bond for Mr. Carter?
Your Honor, he was on our list to speak to, but I double checked, it was not a first.
All right, you'd like me to pass that one?
So, Your Honor, he was on our list to talk to, but I looked, this is a second FTA on an arraignment, so I
Okay.
didn't think to address bond.
All right, thank you. Mr. Carter, what we were trying to ascertain, sometimes if it's a first appearance, you're entitled to argue bond. It doesn't look like this is a first appearance that you failed to appear for. So the court is going to not argue bond today. It's 23M 2791. It's a failure to appear. Bond is set in the amount of $800 cash or surety. Your next court date is Division R on April 2nd for arraignment at 1:30. And I will appoint the Public Defender's Office to represent you if you remain in custody. Okay, sir?
Can I just plead guilty today?
I am not able to handle your
Great
case
idea.
today. Today's just an advisal. So Division R, April 2nd, if you send a kite to the public defender, if you want to try to see if you couldn't add on to a sooner court date, that'd be the best way to do it. So send a kite to the public defender.
Okay.
Okay, if you want to try to add on sooner than April 2nd.
And Your Honor, on Ramirez, I do see the 507 bond number, but I actually think that he's FTA'd twice and that he's no longer eligible either. I
Okay,
think the minutes showed a second FTA.
okay. Ms. McGann, do you agree with that or you would like more time with Mr. Ramirez? Okay, we'll move on. I'll note that and I'll take a look at the minute order as well. Thank you, Mr. Paulson. So how about Mr. Greenwood?
He's not here yet, Your Honor. He's here.
Okay. I'm striking out. How about, that one will need the public defender. How about Sherman Kaiser?
Your Honor.
Good morning, Mr. Kaiser.
Morning.
You're here on an out-of-county matter out of Denver. It's 23 CR 5228. I did review the case and so did Denver to see if you qualify for a hearing within 48 hours. It looks like you do not qualify for a hearing within 48 hours. Nevertheless, we will notify Denver that you're in Adams County to arrange for your appearance or transport. Okay, sir, your bond amount is $2,500, cash surety or property with SRP. Okay, sir? Thank you.
Sir, Denver. Oh, it's Denver. Okay.
They woke him up for that. That's just rude.
All right, we could call Anthony. Is it Tadio? Good morning, sir. Sir, you're here on an Adams County matter, which is 22T843. It's a failure to appear. And I show bond in the amount of $1,000 cash or surety. The next court date is Division 3 on March 27th for a setting of a revocation at 1:30. And I will appoint the Public Defender's Office to represent you if you remain in custody. And then the other matter I need to notify you about is out of Edgewater. The number is 49722, and it's a failure to appear. Bond is set in the amount of $100 cash or surety. Okay, sir?
Okay.
All right, thank you.
I'm about to ruin this video for you guys watching because she's doing something that I normally don't pick up on at all. And maybe because I have a cold, I'm picking up on it. But she keeps going up at the end of her sentences. And it's really hard for me to pay attention.
Okay, I think those are all the matters that I could call. I could call some of the refusals. Let's go ahead and call Ryan Haltom. Mr. Haltom's out-of-county matter is 24M1534 out of Jefferson County. He's refused to appear. I show that he is entitled to a hearing within 48 hours. So we will notify Jefferson County of that to schedule that hearing.
Your Honor, how about Mr. Garcia, Angelo Garcia? Is that one?
Is that one that the defense needs to tell me the credit he's entitled to?
Oh, I don't know.
I show it's going to be a credit
One that
for the amount of time he served in jail. We can call Don Santa Steven is a refusal on the Adams County matter. It's 23T9341. It's a failure to appear, not entitled to a hearing today. $2,000 cash or surety. The next court date will be Division R on April 2nd for arraignment at 1:30. Public Defender's Office is appointed if he remains in custody, or he remains in custody. And then El Paso County, the 24 CR 552. I show that he does qualify for a hearing within 48 hours on that matter. And we will let El Paso County know that and arrange for that hearing. He's refusing to appear today, though. And then Chanel Quintana. In this case, it's 23, Chanel Quintana is refusing to appear on 23 CR 3138. The bond amount is 25, I'm showing a different amount.
I think that she was seen in the last couple days and they've already set new court dates and new bonds on both of these cases.
Did they set it at 2,500 cash or surety? Because my sheet says 5,000 cash or surety, but then the clerk notes 2,500.
1 second, let me look. Yeah, I noticed this weird discrepancy this morning.
I can pull it up as well. Let's see. Do you know?
Yeah, I got it from your minutes. Yeah, I saw 2,500 cash surety and then a new court date of 4/15.
Okay, I do see it's previously said. I probably should still fill out the paperwork that the public defender is appointed if she remains in custody. 2,500 cash or surety, setting of preliminary hearing at 1:30. It was previously set for April 15th. And then the 23M2271. You're indicating, I show here that it does look like a judicial officer already granted a $500 PR bond. Okay. Mr. Paulson's nodding his head for the record.
Sorry, yes.
And then, so that'll be a $500 PR bond, Division R, April 15th for arraignment at 1:30. I guess we don't need to appoint the public defender there unless they remain in custody. I'll just appoint him just in case. And then the Denver matter is 22 CR 4922. On that matter, bond is set at 2,500 cash surety of property, and for pretrial's benefit, the defendant does not qualify for a hearing within 48 hours. This is a post-conviction matter. So I've noted that. Thank you, Mr. Paulson. That is an unusual one.
Your Honor, the 23 CR 3138 case, what division is that going to be set in?
I can't hear you. I'm sorry. Something about 23 CR 3138? That is 2,500 cash or surety.
She's asking what division, Your Honor?
Division 4 on April 15th for a setting of preliminary hearing at 1:30.
She
It was
got-
previously said.
She got that long number. And she
Thank
didn't
you.
get the English words that went with it.
It's like a game of telephone. Okay.
You should be able to do it. Okay, I'll let her know.
Are we ready on any other matters?
The Broomfield case, Mr. Margulis? Yeah. Mr. Margulis is ready, Your Honor.
What matter is this?
Margulis, the Broomfield matter?
Okay. This is 24 CR 32. Again, 24 CR 32. And do you wish to argue bond today?
Your Honor, we're asking to reserve bond. It looks like Mr. Margulis is on a parole hold. I will note he seems to have some other open warrant matters. Will he be seen in out-of-county advisements today, or when should we expect that to happen?
On other matters? Because I only know about this one.
He has open warrants in Boulder, Larimer, Broomfield, Jefferson County, and Denver.
Okay, and
Wow.
unfortunately, I was just, this looks like it was added on. I was informed we are going to just address 24 CR 32 out of Broomfield today. I'm luckily have the benefit of having the clerk in the courtroom with me who does the out of counties. We don't have all that information that you now put us on notice of, but we'll coordinate for an out of county advisement. It could be as early as this afternoon. Is that right? It'll probably either be this afternoon or maybe tomorrow. Okay, as far as this case though, the 24 CR 32, I'll go ahead and appoint the public defender's office if you remain in custody. Bond is set at $50,000, cash or surety, and I'll note that bond argument is reserved. The next court date will be Division 1 on April 4th for a setting of a preliminary hearing at 1:30 in Broomfield.
Why is it 50,000?
That's the scheduled bond for the charges. And bonds reserved, so you and your attorney can argue at that. And we'll try to make sure.
Do you want me to fill this out though? Does that make sense?
He's shocked and he has all of those warrants. What do you think he was expecting?
How? Well, hold on one second.
Thanks to technology, we do not have to hold on 1 second.
Yes, this is not a first failure to appear, so I'm going to go ahead and move forward. I don't believe that bond can be argued today. I think that was an error. So Mr. Ramirez? Good morning, sir. So on 23T10977, it's a failure to appear and bond is set in the amount of $507. The court notes that there are multiple failures to appear, one on December 28th and one on February 23rd, so you're not entitled to a hearing today. The court will go ahead and maintain that 507 cash or surety bond. The next court date is Division R on April 2nd for arraignment at 1:30. and I will appoint the public defender's office to represent you if you remain in custody. Sir, I have to advise you about your other matter. You are entitled to a hearing on that case. So on 23M 3638 out of Weld, it was a failure to appear and bond is set in the amount of $100 cash or surety. I reviewed that and I do believe you're entitled to a hearing within 48 hours and so does Weld. So we'll arrange for that hearing so you can argue bond on your Weld County matter. Okay, sir? Thank you.
$507 bond, that's an odd amount. Usually that means some kind of code, but I don't know what the code means.
I can try to use Ms. Citizen's notes to get through the rest of the folks.
We could also do Angelo Garcia. It's just a matter of how much time credit. Just so you know, that's one. It's just a 30 days jail and how much credit.
Okay.
Angelo Garcia. Good morning, sir. This is 23T6770. It was a failure to appear. It was a no bond out of Division R, and he is supposed to serve 30 days in the Adams County Jail. So the court can go ahead and impose that sentence now if there's a calculation for how much credit he's entitled to.
Do probation or do.
That would be funny, Kelly, if he doesn't get out because of the $7. Oh my God.
Adams County, Western. And I did go to court. They gave me suspended 30 days with 40 hours community service. And I've been locked up since, and they gave me till March if I was out, but I'm still locked up, so.
Where were you in custody?
Here.
Oh, what, thank you.
On the DFT.
I show the warrant was canceled on March 25th.
And it appears he was in Adams on another case and just looking it up to see if the warrant should have been canceled earlier. What's your date of birth?
7/29/82.
And if you need more time, Miss McGann, let me know. What's the word? Any word on this?
Yeah, so.
Without him going to either of his appearances?
So, Your Honor, it does look that Mr. Garcia was in custody in Adams County on 23 CR 3353, starting on October 31st of 2023. The failure to appear in this case was this case was closed on the 21st of 2023, while I believe he was in custody in Adams County anyway. So I'm not sure why a warrant was issued in this matter if he was still in custody in Adams County on the 2023 CR case.
Okay, it sounds like it's a little more complicated than we anticipated. Why don't we go ahead and pass on it? I'll give Mr. Paulson an opportunity to look at it. I can look at it as well, and we'll figure out where to go. I did receive verification that Mr. Gallegos, I think his matter was handled in 307, and so he is on his way back to the jail, and so we'll have him appear in the normal course as soon as he's there. And we do have our Spanish interpreter back, so we can call those matters. Okay, let's call Ramirez Serrano.
Vamos a llamar a Ramírez Serrano.
Mr. Ramirez Serrano, good morning.
Señor Ramírez Serrano, buenos días. Good morning.
This is case number 24T651.
Este es 24T641.
This was a failure to appear.
Esto fue una falta de comparecencia.
We anticipated bond might be set at $257 cash or surety.
Nosotros anticipamos que la fianza va a ser establecida en $257 efectivo o garantía.
But the people have reviewed the case and I believe that they are stipulating or agreeing to a PR bond.
que la fiscalía ha revisado el caso y creo que están estipulando o acordando una fianza bajo palabra.
Is that correct for the people?
¿Es correcto esto para la fiscalía?
Yes.
Sí.
All right, sir. I'm going to go ahead and authorize a personal recognizance bond, or what's called a PR bond.
Muy bien, señor. Entonces lo que voy a hacer es autorizar lo que se llama una fianza bajo palabra.
And that'll be in the amount of $250.
Y esto va a ser en el monto de $250.
The next court date is Division R.
La próxima comparecencia va a ser en la división R
At 1:30 for arraignment.
a la 1:30 para comparecencia.
And I can either choose April 2nd or April 16th.
Perdón, a la 1:30 para lectura de cargos. Y usted puede elegir ya sea el 2 de abril o el 16 de abril.
Any preference?
¿Alguna preferencia?
16 de abril. 16 de abril.
16th, April 16th.
Okay. It'll be Division R on April 16th at 1:30.
Muy bien, entonces va a ser en la división R el 16 de abril a la 1:30.
So you're being released on your own promise to come back to court that day, okay, sir?
Entonces, usted está siendo dejado en libertad bajo su promesa y palabra de honor de que va a volver al tribunal en esa fecha. ¿Está bien, señor?
Ok, sí, muy bien, gracias.
Okay, yes, very good, thank you.
Assuming you do not have any other hold, you'll be released as soon as the jail can process you out, okay, sir?
Y suponiendo que no tiene ninguna otra razón para ser retenido, entonces usted puede salir bajo palabra tan pronto como lo vengan a buscar. ¿Está bien?
Ok, muchas gracias.
Okay, thank you very much.
Thank you, sir.
I told you, Jim. I told you I was going to ruin it for you. But did you hear the interpreter? She nailed it. She went up at the end as well. It was awesome.
Gracias, señor.
Thank you.
Okay, we can go ahead and call Mr. Gul Martinez or Gail Martinez.
Vamos a llamar al señor Gael Martínez.
This is 24M1312.
Esto es 24M1312.
The court does need to issue a mandatory protection order.
La juez tiene que emitir una orden obligatoria de protección.
It is an alleged act of domestic violence, so the Brady Act applies.
Se alega que es un acto de violencia doméstica, así que la ley de I'm sorry, what act, Your Honor? Can you repeat that?
The Brady Act.
Gracias. La ley de Brady se aplica.
The court will check provisions 1 through 6 and 8B. You're to have no contact whatsoever with Jessica Vasquez, 12/14 of 1982.
Entonces la juez va a marcar las previsiones de la 1 a la 6 y 8B. Usted no puede tener ningún tipo de contacto con Jessica Vázquez, nacida el 14 de diciembre de 1992.
That means no contact directly or indirectly through any means.
Eso significa que no puede contactarla ni directa ni indirectamente de ninguna manera.
Additionally, you have an obligation to relinquish any firearm or weapon within 24 hours of your release from custody.
Adicionalmente, usted tiene la obligación de renunciar a cualquier arma de fuego o cualquier tipo de arma que posea dentro de las primeras 24 horas de haber sido dejado en libertad de custodia.
And within 7 days of your release from custody, you must file an affidavit with the court that you've complied with that provision.
Y dentro de los primeros 7 días de haber sido dejado en libertad, usted tiene que presentar una declaración jurada con el tribunal indicando que usted está cumpliendo con esa previsión.
Do you understand that obligation, sir?
¿Entiende esa obligación, señor?
Sí, sí lo entiendo.
Yes, I do understand.
All right. Bond argument on behalf of the defendant.
Ok, argumento para fianza de parte del acusado.
Thank you, Judge. We would ask the court to consider a PR bond for Mr. Gil Martinez.
Gracias, juez. Queremos pedirle que considere una fianza bajo palabra para el señor Gael Martínez.
We would also ask the court to consider a civil assist.
También queremos pedirle a la juez que considere una asistencia civil.
Mr. Gil Martinez has been in Colorado for 20 years and he's been at the same address for 14 years.
El señor Gael Martínez ha estado en Colorado por 20 años y ha estado en la misma dirección por 14 años.
Because the protection order, he's going to leave to a friend's home.
Eh, Dada la orden de protección, él va a irse a la casa de un amigo.
He is working full-time in maintenance on the same job for 9 years.
Él ha estado trabajando en la posición de mantenimiento tiempo completo por 9 años en la misma posición.
He does have children that are in college and he sends money to them frequently.
Él tiene hijos que ya están en la universidad, entonces él les manda dinero frecuentemente.
Freeloaders.
He does have a car to get himself to court.
Él tiene un carro para poder llegar al tribunal.
He is not on probation anywhere that I could see.
Él no está con probatoria en ningún lado que yo pueda ver.
I couldn't find his criminal history and data access, but the CPAT shows that he has no FTA history dating back to 1998.
No pude encontrar ninguna historia penal ni acceso a la información, pero lo que aquí veo es que no se muestra ningún problema con falta de comparecencia y esto va hasta 1998.
He is a CPAT of 2. We would ask the court
El,
to consider a PR bond.
el resultado del CPAP de él es 2, así que le queremos pedir a la juez que considere una fianza bajo palabra.
Thank you. On behalf of the people,
Gracias.
you,
De parte de
Honor.
la Fiscalía,
The people would request schedule or some sort of secured bond.
la Fiscalía quiere pedir la fianza que se ha establecido o algún tipo de fianza asegurada.
We recognize he's a CPAT 2 and doesn't have meaningful failure to appear history, if any.
Nosotros reconocemos que el resultado del CPAP de él es 2 y no tiene ninguna falta de comparecencia significativa, si es que tuviera alguna.
We are concerned about community safety.
Estamos preocupados acerca de la seguridad de la comunidad.
The defendant has a prior conviction with the same victim from 2021 and some
El,
sort of domestic violence contact in 2023.
el acusado tiene una condena anterior del 2021 con la misma víctima y algún tipo de contacto con la ley en el 2023 por violencia doméstica.
Thank you.
Gracias.
thank you. The matter comes on for an individualized bond argument.
Gracias. La causa está frente al juez para un argumento sobre fianza individualizado.
The court has considered the arguments of counsel, the pretrial services report, and the rest affidavit.
La jueza ha considerado los argumentos de los abogados, el informe preliminar y la declaración jurada del arresto.
The court notes that defendant has a low risk category, a category of 2, a score of 19.
La juez nota que el acusado tiene una categoría 2, que es menor, y también una categoría de riesgo 19.
It appears that he has stability in the community and steady employment.
Parece que él tiene estabilidad en la comunidad y un empleo estable.
He has little criminal history included in old false reporting.
Él tiene historia penal limitada, incluyendo una falta de información, perdón, falsa información.
But the court is concerned on the other side that there is a previous domestic violence conviction, and the domestic violence summary indicates that there has been a number of domestic violence incidents, many of which have not been reported.
La juez está preocupada en cuanto a que existe ya una historia de violencia doméstica, que ha habido otra condena y un sumario de un número de incidentes de violencia doméstica y algunos de los cuales tal vez ni siquiera fueron reportados.
The court does not see that it was drugs or alcohol that specifically contributed to this incident.
La juez no ve que hayan habido drogas o alcohol específicamente relacionados con este incidente.
So balancing all those factors, though, the court is going to set bond in the amount of $1,000 cash or surety.
Entonces, considerando todos estos factores, la juez va a establecer la fianza en el monto de $1,000 efectivo o garantía.
Slightly below the customary amount.
Es un poquito más arriba del monto acostumbrado.
I did consider a cash-only option, but in light of the prior domestic violence conviction, the court is not going to authorize that.
Y sí consideré una opción de solamente efectivo, pero a la luz de la historia anterior de violencia doméstica no voy a autorizarlo.
The court will appoint the public defender's office if he remains in custody.
La juez va a asignar a la oficina del defensor público si es que él permanece bajo custodia.
The next court date is Division 4 on April 28th for arraignment at 1:30.
La próxima fecha de comparecencia va a ser en la División 4 el 28 de abril para lectura de cargos a la 1:30.
Thank you.
Gracias.
Would the court authorize a civil assist?
La juez va a autorizar una asistencia civil.
Yes, the court will, at the requested offense, allow a civil assist. What that means is with assistance of law enforcement only, you may retrieve any undisputed property of yours from the residence.
Sí, la juez va a autorizar, perdón, una asistencia civil. Esto lo que significa es que solamente con la compañía de la ley usted puede acercarse de nuevo a la casa y recuperar cualquier propiedad que esté indisputada.
Interpreter, would you ask him to print his name and then sign his name on the form?
Señor, por favor, ¿puede escribir su nombre y después poner su firma en el formulario?
Your entire name.
Su nombre completo.
Do you own any firearms?
No,
¿Usted tiene algún arma de fuego?
no tengo arma.
No,
Mark
I don't
box
have
one.
firearms.
Box
Marque
one
el
says you
casillero. Marque el casillero número 1. El casillero número 1 dice usted no tiene armas de fuego.
print your name and sign your name.
Ponga su nombre y escriba su nombre.
This is your copy.
Esta es su copia.
That's all. Gracias.
Thank you.
Thank you. We can next call Joseph Zhao.
Y ahora vamos a llamar a Joseph Gell.
Really quick for the new people, the stream ended a while ago, but I had this clip of this court that I've not seen yet. I don't know what's in it. I don't know if it's good. I don't know if it's bad. We're just watching it together.
Good morning.
Buenos días.
This is case number 24CR 927.
Este es el caso 24CR927.
The court needs to issue a mandatory protection order. It is an alleged act of domestic violence, so the Brady Act does apply.
La juez necesita emitir una orden obligatoria de protección. Esto es un acto de violencia doméstica, así que se aplica la ley Brady.
The court is going to check provisions 1 through 7 and 8B. You may have no contact whatsoever with Jocelyn Bernadin. It's 1/8 of 92, and that's spelled Bernadin.
La juez va a marcar las previsiones de la 1, la 7 y la 8B. Usted no puede tener ningún tipo de contacto con Jocelyn Bernardine, que nació el 8 de enero de 1992.
Additionally, you have an obligation to relinquish any firearm or weapon within 24 hours you're released from custody.
Adicionalmente, usted tiene la obligación de renunciar a cualquier arma de fuego o cualquier otro tipo de arma dentro de las primeras 24 horas de haber sido dejado en libertad.
And within 7 days you're released from custody, you must file an affidavit with the court that you've complied with that provision.
Dentro de los primeros 7 días de haber salido de custodia, usted tiene que presentar una declaración jurada con el tribunal indicando que cumplió con esa previsión.
Do you understand that obligation, sir?
¿Entiende, señor, esa obligación?
He said, see. Say it again.
He said yes. Yes.
Okay, thank you, sir. And is there a bond argument on behalf of the defendant?
Ok, gracias, señor. ¿Y existe un argumento sobre fianza de parte del acusado?
Yes, thank you.
Sí, gracias.
Your Honor, we would ask the court to consider a PR bond for Mr. Zhao.
Su señoría, queremos pedirle que considere una fianza bajo palabra para el señor Yale.
We would also ask the court for a civil assist.
También queremos pedirle a la juez para una asistencia civil.
Mr. Zhao is working currently and he's also paying rent.
El señor Yael en este momento está trabajando y también está pagando renta.
He's aware there will be a protection order issued today and he's going to stay at a friend's home.
Él está enterado de que se va a emitir una orden de protección el día de hoy y él va a permanecer fuera de la casa.
He said that he is going to pay to take the bus to court.
Perdón, que va a quedarse en la casa de un amigo. Él dijo que va a pagar para tomar el autobús para llegar al tribunal.
He does not have any help to bond currently. He's hopeful that maybe a friend will help him bond out and he can work off the bond money.
Él en este momento no tiene ninguna otra fianza y tiene la esperanza de que un amigo lo va a ayudar a pagar la fianza y va a poder trabajar para pagar esa fianza.
I could not find in data access, but from talking to him, it sounds like he's on a $1,500 bond in the other traffic matter.
Él no pude encontrar ningún acceso a la información en Data Access, pero parecería de lo que él dijo que él tiene una fianza de $1,500 en la otra causa de tránsito.
He has no FTA that I could see and no criminal history other than this traffic charge that shows on the CPAT.
Él no tiene ninguna falta de comparecencia ni ninguna otra historia penal más allá de de tránsito que se muestra en el CPAP.
He does have a 4-year-old son that he does send money to every week, depending on how much money he makes.
Él tiene un hijo de 4 años a quien le manda dinero todas las semanas dependiendo de cuánto dinero gane.
He does have an aunt here, his wife, and a friend here as well, friends here as well.
Él tiene una tía aquí, su esposa y también un amigo.
He is a CPAT of 1, Your Honor. We would ask the court to consider a PR bond.
El resultado del CIPAP para él es 1, su señoría. Le queremos pedir que considere una fianza bajo palabra.
Thank you. On behalf of the people?
Gracias, de parte de la Fiscalía.
Your Honor, we're asking for some sort of bond. I'm not asking for schedule necessarily.
Su señoría, estamos pidiendo algún tipo de fianza. No necesariamente voy a pedir lo que se ha establecido.
I am concerned because of the 2 cases being picked up in very short order.
Estoy preocupado acerca de los casos que agarró en un orden muy reciente, muy corto.
And the people have serious concerns about the knife use in this circumstance.
Y la Fiscalía está preocupada muy seriamente en cuanto al uso de un cuchillo en este caso.
I think a bond is appropriate in light of the DV nature and the fact that a non-DV victim did get injured, though is not pressing charges.
Counsel, can you repeat that, please?
I think a bond is appropriate in light of the domestic violence nature of this incident and a non-domestic violence individual being injured who doesn't want to press charges.
Thank you. Entonces, creo que una fianza sería apropiada en este caso a la luz de la naturaleza de violencia doméstica de este hecho y también el hecho de que existe una víctima no parte de la violencia doméstica que fue lastimada y que decidió no presentar cargos en este caso.
All right, thank you. First of all, the court will go ahead and authorize a civil assist. With the assistance of law enforcement only, you can retrieve any undisputed property of yours from the protected residence.
Muy bien, entonces la juez primero va a autorizar una asistencia civil. Solamente con la asistencia de un oficial de policía usted puede acercarse a la casa y sacar cualquier pertenencia que no esté disputada de esta propiedad protegida.
The court has, by virtue of the protection order, prohibited the possession or consumption of alcoholic beverages or controlled substances.
Dentro de la orden de protección, la juez está incluyendo la prohibición de sustancias reguladas o alcohol.
And that is supported by the arrest affidavit.
Y esto está todo apoyado por la declaración jurada del arresto.
The court does consider the arguments of counsel, the pretrial services report, and the arrest affidavit.
La juez considera los argumentos de los dos abogados, el informe preliminar y también la declaración jurada del arresto.
The court notes that it's a very low risk category, a category 1 score of 4.
La juez nota que es una categoría muy baja de riesgo 1 con categoría 4.
On the other hand, he's only been in the area for a limited amount of time and doesn't have the strong stability in the community.
Yo entiendo que él ha estado en el área por un tiempo muy limitado y que no tiene lazos muy fuertes con la comunidad.
The fact that he does have these two matters in short order, both involving use of alcohol or drugs, the court is concerned.
Dado que él tiene estas dos causas seguidas en un periodo muy corto de tiempo y que los dos involucran el uso de alcohol, es una preocupación.
And the court also notes that there was an independent witness to this incident.
Y también la juez nota que hubo un testigo independiente en este incidente.
So the court is not convinced that a PR bond is appropriate.
Entonces la juez no está convencida de que una fianza bajo palabra sea apropiada.
But the court does believe that a $1,500 cash or surety or a $150 cash only option with SRP or monitored sobriety is appropriate.
Pero la juez cree que $1,500 de efectivo o garantía o solamente efectivo de 150 con monitoreo de sobriedad sería apropiado.
The court will also appoint the public defender's office if he remains in custody.
La juez también va a asignar al defensor público si él permanece detenido.
The next court date is Division 7 on March 28th for return of filing of charges at 1:30.
La próxima fecha de comparecencia va a ser en la División 7, el 28 de marzo a la 1:30 para vuelta para presentar cargos.
And if we could have the assistance of the interpreter.
Sir. Interpreter, please ask him to print his name and then sign his name on the form.
Por favor, escriba su nombre y luego firme. Ponga su firma.
Sign.
Firme.
Do you own any firearms?
¿Usted tiene algún arma de fuego?
No.
Mark box 1 that says you don't own any firearms.
Marque el casillero número 1, indicando que no tiene ningún arma de fuego.
Print your name and sign your name.
Escriba su nombre y después ponga su firma.
This is the supervised release program.
Este es el programa de libertad supervisada.
You need to call this number within 24 hours after you get out of jail.
Tiene que llamar a este número de teléfono dentro de las primeras 24 horas después de salir de la cárcel.
If you don't call them within 24 hours after you get out of jail, they'll put out a warrant for your arrest.
Si no los llama dentro de las primeras 24 horas de haber salido de la cárcel, van a poner una orden de arresto contra usted.
This is your copy of the protection order.
Esta es su copia de la orden de protección.
That's all.
Muchas gracias.
Thank you very much.
All right, I believe that concludes our Spanish matters. Do you want the interpreter to just make sure?
Please.
If you could just make sure that nobody else needs the Spanish interpreter's assistance?
¿Alguna otra persona necesita la asistencia de la intérprete de español?
I don't see anyone. Thank you.
Thank
you,
you.
Your Honor.
Thank you. Have a good day.
You too.
Oh, wow, that was great. Nothing bad happened. Nothing broke. No terrible cases. So, domestic violence, domestic violence, domestic violence. That's my normal day. I have to go through like 123 domestic violence hearings like that, and then I get someone good. But at least it wasn't bad. I gotta go get ready for courts to get open. I can't be late. Definitely have to set up for Australia. I'm gonna try to get at least 1 hour up today, and I know that I can. I might even get more than 1 hour. I don't expect anyone to actually watch all these because it's so long, and but she's really good. I mean, she is elite. She is really, really elite. You just like fast forward through it a bit and just stop every once in a while. It doesn't matter where you stop. She is on point. And that the poor guy that she's against he is not elite. He is not. No, thanks, Cha. Thanks for asking me to do that. I feel like I got some work done while I was in here. Nope, not going to work today. I'm just gonna take the day off. I'm gonna take the day off and work and play in Australia. Chrysanthemum. I hope I said that right. Chrysanthemum. Anyway, I'm gonna send Carolyn a picture of my toilet flushing so that she sees which way it's going. All right, guys. Thank you so much for coming out tonight, this morning, tomorrow. I really, really, really appreciate it. Oh, oh, Chris. Chris, I'm so sorry. It's over. Oh, you poor thing. That's right. There was nothing going on for a while anyways. It was fun for me, though. I kept forgetting there was chat because I was into the court. Chrysanthemum. Chrysanthemum. All right, guys. Have a good day. See you next time. Bye. Chrysanthemum. Oh, I should do it up at the end. That'll make Jen happy. Chrysanthemum. See ya. Bye.